Finally, on the point that we were at prior to lunch, the question of the so-called community of interest and the reliance placed by the respondents on the Dean case. I simply take this court to what the Inner House had to say about that, or the majority of the Inner House had to say about that in their opinion. It's at page 104. And it's paragraph 46, where Lady Smith says, "Further, I consider that there is merit in Mr. Clancy's submission that properly understood this was not an arm's-length transaction. It was in the interest of both NRAM and HCL to ensure that the sale of the unit was completed. Both would benefit financially from the proceeds of sale. In these circumstances, the Lord Ordinary ought not, I agree, to have regarded the case of Dean as being of no assistance. It involved circumstances which, while not identical, were comparable, and furthermore relevant observations about assumption of responsibility in paragraph 28, where Mr. Justice Lightman, having said that great caution was required in treating statements made by a solicitor or the instructions of his client in the course of a transaction as his own representations, went on to consider the position where the solicitor cannot be regarded as acting for his client, and added, quote, the solicitor's position in such a situation is to be contrasted with his position in a situation where the solicitor makes an express unequivocal statement to a third party which is not attributable simply to performing his role as the client's advisor, for in the latter case the advisor may readily be held to have assumed responsibility in the third party, since the explanation of his acting merely as a messenger would be inadequate. Those observations relied on by Mr. Clancy were, in my view, very much in point. I cannot accept that the email can be regarded as equivocal in its terms. Insofar as the heading might, in hindsight, be regarded as conflicting with the body of the email, there was no evidence that it was regarded as such at the time. In any event, it must, I consider, be accepted that the key aspects of the email were unequivocal. NRAM needed to provide Ms. Steele with a letter of non-crystallisation and signed discharges in the form attached as a matter of some urgency, and they needed to do so in circumstances where the whole loan due, for which she had a settlement figure, was being paid off. That was the purpose of the email. Its message was clear and unequivocal. It was also, of course, wrong, but there was nothing in the body of the email to cause doubt as to the veracity of the message, for reasons which I explained below. The resultant harm to NRAM in the form of economic loss was reasonably foreseeable.
Yes, Mr. Clancy, of course, we've got the email helpfully set out on page 47 in the Statement
Yes.
of Facts and Issues.
Yes.
Heading, Limited Sale of Pavilion 1. Helen Neal, I need your usual letter of non-crystallisation for the sale of the above subjects to be faxed through. And then, of course, the misrepresentation. The whole loan is being paid off. When one says it's unequivocal, don't you think that the reasonable reader of that, including the head note, would think, well, sale of Pavilion 1, sale of the above subjects, whole thing being paid off, what's going on here?
Lord, the sale of Unit 1 was not in any way inconsistent with the subsequent misrepresentation that the whole loan was being paid off and a discharge was sought in connection with that, because there's nothing in the letter to tie the sale of Unit 1 to the discharge of the whole loan. And it's perfectly possible that funds were coming from some other source and that the borrower was taking the opportunity to pay off the whole loan.
You're absolutely right. It's possible, but it's fairly unusual, Mr. Clancy. Hence my rhetorical question, what's going on here?
But I would respectfully urge you to guard against making an assumption that it's unusual. There's no evidence to support that proposition. It's a commercial transaction.
Thank you.
The opposing analyses were the Inner House saying this was unequivocal. At the other end, we had the Lord Ordinary saying it was crying out for clarification. And in my respectful submission, it is at the Inner House end. My final submission in relation to this matter is to tackle head-on, so to speak, the plainly wrong test, to say that when one looks at the entire circumstances of the case and leaves aside any question of misdirection or leaving account of irrelevant considerations, and of course my primary position is that these things did happen. But if I happen to be wrong about that, then the question becomes, well, if you look at the totality, what was the correct conclusion to reach? And I've already observed that Lord Brodie was seemed to be pretty much in line with the majority opinion in relation to that matter. So what I wanted to do was just to very briefly summarise, if I may, the totality of the circumstances which I say indicate that the question should be answered in favour of the respondents. First of all, there is the three specific factors which I've relied on this morning, the ones which I summarised in response to a question from Lady Back. The question of requirement to check, the fact that it was out with instructions, and thirdly, the community of interest. The following factors were recognised by the Lord Ordinary as being in favour of the respondents. I'll simply give you the paragraph numbers in his opinion and put a label on them. He accepted at paragraph 66 that the appellants were not assisted by protection given in simply transmitting information on behalf of a client. He accepted that at paragraph 70 there was no question of other remedies available to the respondents against HCL. At 71, he accepted that the duties desiderated were not inconsistent with duties which the first defender owed to HCL. In the same paragraph, he acknowledged that the result in favour of the respondent would not create any risk of indeterminacy in claims. In paragraph 73, he accepted the absence of the disclaimer as relevant. He accepted the apparent urgency of the situation as being a relevant consideration. He accepted that it was a direct communication from the solicitor to the principal on the other side, bypassing any legal representation for the respondents was relevant. He accepted that this was a trustworthy source. A solicitor, in the normal course of events, is someone that people would readily trust. He could have added at that stage in my submission that not only was there this general concept of trustworthiness, but there was also a track record of direct dealings between this solicitor and the respondents in two previous transactions, which were relatively recent. One was the sale of the first of the units covered by the security, and the other was the discharge of a loan in relation to a different property. So in my submission, the combination of the two, the trustworthy source with the track record, are important considerations. So our position is that, taking account of all those factors, the Lord Ordinary, if he had given the correct weight to these, and in particular, if he had not attached so much significance to the ability to check, would have been bound to conclude that the duty of care did arise. And that is one feature in my submission of the majority in our House opinion, bringing all these factors together, properly understood. It is clear, in their view, that the duty of care did arise, and in my submission they were correct to do that. Ladies and Lords, unless there are any other questions for me, then those are my submissions.
Can I just ask, just for clarification of something that's been puzzling me, just on as to the facts. The standard security was discharged, but a floating charge remained over the units that the borrower continued to own. And I'm just wondering how I mean, obviously that floating charge would have crystallised to the same effect as a fixed security on insolvency or on winding up. Of course, by the time winding up occurred, all the other units had also been sold, and the floating charge had been released from all that land. And I'm really wondering how the loss of the standard security over Unit 1 actually affects the bigger picture. It's not part of the appeal before us, so it's just my own curiosity. And if you don't know, it doesn't really matter.
I regret to say I don't know off the top of my head, and I rather think that that was never established in the facts. It was never disputed that the discharge paved the way to the sale of the remaining unit, my Lord. And what happened to the...
Well, I think there are findings in the Lord Ordinary's opinion that there were 2 subsequent sales, namely of units 2 and 4, and in each case the bank granted a certificate of non-crystallisation, thereby enabling the sales to take place. What we don't obviously know from the findings is that the bank, having done so, why the proceeds of sale were not paid to them. But you can't answer.
No. Okay.
Thank you. Mr. Hawkes?
Nothing to add.
Mr. Duncan?
My ladies, my lords, just fairly briefly, if I might, just come back on 1 or 2 points. Firstly, on this question of the appellate court's jurisdiction. As I said earlier, on all questions of primary fact and of inference and of evaluation, the mood is of caution. The appellate court must be cautious about interfering. It is not, as my learned friend put it, a question of willingness to interfere. And where more authority needed on that, one could go to the case of Daytech, which brings in the case to do with the trawler, which my learned friend referred to Todd's case, and that's at tab 9. But I remain of the view, and in my submission, that the best example of how the appellate jurisdiction should be approached in a case like this is the Royal Bank of Scotland against Carlisle at tab 24. In that case, all 3 types of question were under review before the inner house: primary findings, secondary findings of fact, and evaluation involving the application of a vague legal standard, as I mentioned earlier. The case is of some interest too, because that was also a case where an appellate court, on this occasion, this case, made expressions of sympathy regarding the position that the respondent found itself in the sense that, I think, as my Lord Hodge said at paragraph 20 of that case, had he been deciding the case at first instance, he might well have reached a different view, but he wasn't. The reason why there is caution, particularly in relation to evaluation, it might be said, is because the process of reviewing the evaluation, of reviewing the application of the legal test, is very difficult to unpick from the fact-finding process as well. And one sees that being discussed in the case of B, in particular, what Lord Kerr says there at paragraph 113. Moving then to the reasons why my learned friend said that the inner house could intervene. In a number of the exchanges, the court identified and raised with Mr. Clancy instances of the findings of the Lord Ordinary perhaps not sitting alongside or being at one with the findings of Lady Smith, in particular what she said at paragraph 49, and my Lord Hodge raised one particular instance of that with my learned friend. There's another one, at least, that appears in paragraph 49, which we raise in our case. In paragraph 49, Lady Smith says that Mr. Clark had not accepted that he should check the email. And of course, as my learned friend has just said, we have also Lady Smith's observations about the email, as she sees it, not being vague and not being ambiguous. But the fact of the matter is that the Lord Ordinary heard from Mr. Clark on this matter in cross-examination. And when the Lord Ordinary came to ask himself what would the hypothetical recipient have made of that email, it's not a bad start from my point of view, that the actual recipient in cross-examination finally accepted that the email was indeed vague and ambiguous, and that's recorded in the Lord Ordinary's findings at paragraph 77 at page 135. And it's not without importance, I would suggest, that the Lord Ordinary's finding is not indicative of my constructions of things just making it over the line. He said that the email cried out for clarification. This was not a marginal case. Moving on to a further matter, and in this question of whether without checking is something that the Lord Ordinary has added to the test in relation to negligent misrepresentation, and added something that's not to be found elsewhere other than possibly in Lord Oliver's observations in Caparo. In fact, if one were to go also to Customs and Excise, again it's at tab 9, and I'm thinking in particular at page 639, if one were to go to what Lord Hoffman says there, one sees that the question in a question of reliance is whether the provider of the information has assumed responsibility rather than somebody else having that. And that seems to me very much in line with the requirement to check. The next matter I want to pick up on is just the various exchanges and submissions that were made in relation to the Gran Gelato case. And I would like, in that regard, not thinking so much about the observations going back to Nocton's case, but in particular thinking about the relevance of the rule that's discussed by Sir Donald Nichols regarding solicitors. We have always accepted that that rule is irrelevant to this case, and the reason for that is explained by Sir Donald Nichols himself in White and Jones. And again, I won't turn it up, but it's at tab 32 at page 1341. In a reliance case, the rule that's discussed in Gran Gelato has no relevance at all. And for the reasons raised by my Lord Reid, I would also suggest that the whole question of agency is irrelevant too, the fact of the matter being that an agent who is acting within authority can still owe a duty of care to a third party. Next, if I can very briefly just mention the case of Dean, it is clearly distinguishable in my submission, and the exchange with the court already indicates that. There are clear points of distinction. The case, as has already been indicated, I think perhaps in relation to questions from my Lord Hodge, it's at tab 10, of course, and it's page 687. As my Lord Hodge, I think, indicated in some of his questions, the case differs from the sort of case that's being advanced here. In particular, when we look at Lord Justice Sedley and Mr. Gavin Lightman, we see that they did very much follow the White and Jones approach of using White and Jones and also the discussion in Gorham to fashion a legal remedy. And Lord Justice Robert Walker says in terms at paragraph 55, page 703, that a Caparo advisor type case wasn't being articulated. So it's a different sort of case. The second point of distinction is, again thinking in particular about what Lord Justice Robert Walker says, it was also a case where the appellate court was very careful about whether it was able to intervene. And we see that at the very start of his discussion at paragraphs 51 and also at 56. And then finally, and most importantly, is that it is distinguished on the facts. The facts found by the Lord Ordinary were that there, in this case, were that there was no community of interest, whereas Mr. Justice Lightman and Lord Walker record different facts in that case. So for all those reasons, the case falls to be distinguished. And for those reasons, I would once again invite the court to refuse the appeal.
Thank you very much indeed. We're grateful to everybody who's been involved in the submissions before this court, not only those who've been on their feet, because I feel sure that those sitting beside them and those behind them will have had something to do with it. So thank you all very much indeed. And we shall now retire to consider what conclusion we shall reach and let you know in the usual way. Court is now adjourned.